Case number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, I should say.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor.
I have asked, I've went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, yes, sir.
Okay, you are charged with one count of stopping after or failing to stop after an accident or leaving the scene of a crash or accident. A violation of section 335.12A1 of the Conneaut City ordinances. If you're convicted of this offense, it's first degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yep.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
Yes, sir.
Okay, will you be retaining an attorney?
Yes, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes.
The video opens with a sharp introduction, warning viewers. They're about to see a defendant who insists on representing himself in court, also known as pro se. Right from the start, the narrator highlights the irony of the situation. People think it's easy to do thanks to internet tools and videos, but quickly discover it's far more complex in a real courtroom. We see the judge call the case formally, addressing the defendant politely while maintaining a firm, professional tone. Mr. Colton responds with a question about getting a crash report, already indicating he doesn't fully understand the procedural boundaries of this early hearing. The judge quickly redirects, pointing out this is just the initial appearance and that evidence requests come later. It's clear from the judge's tone that he's used to these questions and is prepared to handle them without wasting time. Despite the defendant's uncertainty, the judge explains where he can get the report, laying the groundwork for a structured process. This exchange shows how judges keep initial hearings focused and don't allow them to turn into full-blown discovery battles. It's a good lesson for viewers on how courts keep order even when defendants don't understand the stages. The moment is also a reminder that polite but firm judicial control prevents chaos. The atmosphere in the courtroom remains formal, but you can sense tension building as a defendant pushes for answers he won't get at this stage. This is a textbook example of the gap between what people think court will be like and what it actually is.
Read and write English for the record.
Yes, sir.
I'll provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, then sign in date at the bottom. Court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Holton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live The ticket has you at 5 West Main.
Yes,
What's the apartment number?
37.
37 in Conneaut. How long have you lived there?
4 years.
4 years? See, Mr. Colton has no prior criminal history in this court. His last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pretrial conference in the near future. We're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court. So make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest. Okay? You could also, the city of County, have $5,000 if you're...
The initial hearing continues. The judge methodically explains the charge Mr. Colton is facing. He reads the statute clearly telling the defendant it's a misdemeanor with serious potential penalties, including up to 6 months in jail and a large fine. The defendant listens quietly, acknowledging he understands, but seems fixated on the crash report issue instead of the gravity of the charges. The judge is thorough, laying out not only the jail time and fines, but also the possibility of being ordered to pay restitution to victims. He warns that even restitution can add thousands of dollars to the final penalty if is convicted. Beyond money, the judge notes a mandatory license suspension ranging from 6 months to 3 years. This careful explanation shows the court's responsibility to ensure defendants know exactly what they face. It's a key part of due process, and the judge delivers it clearly. The scene is a strong reminder that even misdemeanor traffic offenses can have serious life-altering consequences if you don't take them seriously. The defendant nods along, but still doesn't seem to grasp the danger of going pro se. This part of the video also exposes how judges must balance empathy with firmness, making sure a defendant truly understands the risks before letting them waive their rights to counsel. The moment is tense but necessary, illustrating the legal system's safeguards even when people don't appreciate them.
So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting a accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office.
Ask Mr. Colton how he wishes to plead. The defendant confidently says not guilty, which the court accepts without argument. But things take an interesting turn when the judge asked about legal representation. Mr. Colton says he will represent himself. The judge pauses, and you can sense the shift in tone as he warns it's not a good idea. He makes it clear Mr. Colton has a right to do so, but cautions that it's unwise given the legal complexity and possible penalties. This is one of the most instructive moments in the video because the judge explains that having a right doesn't mean it's smart to exercise it in this way. The judge uses humor carefully, likening this choice to doing something you can but shouldn't. It's a subtle but firm way to encourage the defendant to reconsider. Still, Mr. Colton is adamant about proceeding pro se. The judge doesn't fight him, but insists on formal procedure, asking if he can read and write English so the court can confirm understanding. He provides a waiver of counsel document, making sure everything is done by the book. It's a clear lesson in how court protect defendants' rights even when they are determined to make risky choices. Watching the judge's calm professionalism is fascinating. Next voice. With a waiver of counsel signed, the judge officially recognizes Mr. Colton as representing himself. The court now has to move on with the case as if he were his own lawyer. This segment underscores how the legal system accommodates self-representation, but also why judges try to talk defendants out of it first. The judge carefully transitions two questions about bond since there's no formal recommendation from the prosecutor due to this being citation from a police officer. He asks about Mr. Colton's address, confirming that he has lived there for years, showing stability. The judge also checks for prior criminal history, learning that Mr. Colton has none in that court and hasn't had any traffic issue.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting
Issue since 2008. This matters for bond decisions, showing that even while representing himself, Mr. Colton is given fair consideration. The judge ultimately sets bond at $5,000 personal recognizance, allowing Mr. Colton to be released without paying cash as long as he appears at the next hearing. This sequence highlights a balance between enforcing the law and respecting defendants' rights. It's a good reminder that bond decisions weigh both the seriousness of charges and the individual's history. The judge remained polite and professional throughout, demonstrating the importance of due process. Next voice setting bond. The judge explains the next steps to Mr. Colton in clear detail. He tells him he'll need to go to the clerk's window to get the date in time for the next.
I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
Yes.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without...
Next hearing stressing that this is the only official notice he'll receive. The warning is blunt. If he fails to show up, his bond will be revoked and a bench warrant will be issued for his arrest. It's a necessary moment of tough love, making sure there's no misunderstanding about the stakes involved. The judge doesn't sugarcoat the consequences of missing court, highlighting the real-world responsibility that comes with being released on your own recognizance. Mr. Colton seems to understand, nodding and saying yes, but you can sense that tension remains. This part of the video shows viewers how even simple instructions must be delivered carefully to self-represented defendants. Courts know they have to be crystal clear or risk confusion that could derail the entire process. The judge is thorough, explaining the financial risk as well. The city can hold him responsible for the full $5,000 if he fails to appear. This segment is a great example of a judge fulfilling the duty to inform without intimidating unnecessarily. It strikes a balance between authority and fairness that is critical in maintaining trust in the system.